We will start rolling here. So for those that this is the first webinar, we have we as an eWealth, myself, Brian Adamek, we've been doing a ton of webinars and events on Minnesota paid family medical leave. And today, what we're going to do is we're going to talk about what I'll call the basics, but we're going to get more into kind of the employment law and labor laws side of it. And that's where we have special guest Tina kind of presenting on that side. So the first half of it is going to be maybe this might be the first time you've actually seen anything on Minnesota paid leave. And maybe just some of our other webinars that we've done, you'll see more additional slides, additional details. So you might want to check out those. But it's going to be more from the employment law side of it. And so let's start rolling here. The co-presenter, so my name is Brian Adamek, partner wealth advisor at eWealth Partners. We also have Tina Syring from Husch Blackwell. She's joined me on a few other webinars related to this. We're both going to talk about kind of our firms and the work that we do, but say hello, Tina.
Hi, everybody. Thanks for joining today and looking forward to having this conversation.
Yes. And both of us, again, we'll show this kind of in some separate slides, but we work closely with business owners. And so if you are a business owner, even heck, if you're an employee on this, just know that we take it from more of the perspective of what the business owner needs to know. But I think it'd be helpful for any employee as well. All right, so let's just start with what is Minnesota paid leave? Starting with the basics, Minnesota Paid Family and Medical Leave, or PFML. It's a brand new state program launching January 1st of 2026. From your perspective as a business owner, it isn't optional. If you employ even one person in Minnesota, you are in the program. You're either in the program through the state plan or by applying for a private plan exemption. We'll talk about private plans a little bit later. And it gives employees up to 12 weeks of medical leave and 12 weeks of family leave per year with a combined maximum total of 20 weeks. During this time, employees receive wage replacement from the state or the private insurance plan and job protection, which we are going to talk about. Job protection from you as the employer. Job protection means that they're required to return the employee to the same job they left or a job that is equivalent in pay, benefits, and working conditions. Really, the whole idea of the program is to provide workers with income security during major life events, whether that's recovering from surgery, bonding with a new child, caring for a sick parent, or addressing a personal safety issue. We go into kind of the qualifying events. We have medical leave and family leave. On the medical leave, that's leave to care for the individual's own serious health condition. So you get up to 12 weeks on medical leave. On the family leave, they bucket all four of those: bonding, military family leave, caring, and safety. Bonding, think of having a child through birth, adoption, or foster care. Military, think like if someone's called up for active duty. Caring, think, maybe caring for a loved one, a family member, and I guess even Tina, maybe let me ask you this: it doesn't even technically have to be a family member for how it's written.
The statute is so broad, Brian, that it includes somebody that could be a non-relative, a non-blood relative, where it's just somebody like a friend who is dependent upon somebody else needing help. And you don't even have to live in the same household.
Okay. And that's different than a lot of the what Minnesota. I had a previous slide in the past that it's like the eighth or 10th state to do this. That's more liberal compared to a lot of the other states that have put this in place. Yeah.
It's very, very broad. It's one of the most broad paid leave statutes in the country.
Okay. All right. That last family leave is safety. So because of domestic abuse, sexual assaults, or stalking. And so the maximum total between the two is 20 weeks. And the benefit year starts day one of leave. Okay. I know on some of the private insurance plans, you could make that a calendar year. On the state plan, basically they get 12 weeks or up to 20 weeks per year, and day one of that year starts day one of leave. Okay. And we'll go talk through a case of kind of the family bonding piece here in some later slides. Now, how is this funded? Really, it's funded two ways, through employer and employee. I call it a payroll tax. The state calls it a premium. It feels a lot like a payroll tax. If you are a large employer, which is 31 employees or more, that payroll tax or that premium is 0.88%, where half of that is paid by the employer, so 0.44%, and half of that is paid by the employee, so the other 0.44%. If you are a small employer, defined as 30 employees or less, that is reduced down from 0.88 to 0.66. And as you can see on the slide, that reduction comes to the employer, not necessarily the employee. So it's reduced from 0.44 to 0.22. I have a slide on this that will kind of go over this a little bit more in detail. Before we get into some of those other details, who's eWealth Partner? So that's the firm I'm with. What we do, we're a financial planning and wealth advisory firm serving business owners and their families. We're located in Minnesota here, Minnetonka, Minnesota. Most of the business owners that we work with have less than 50 employees. Most of them have less than 30 employees. And what we say is if it touches your business cash flow, it touches the family cash flow, and we know how to plan around that. So like, financial planning, tax planning, investment management, estate planning, that's really what we do. So ultimately understanding how business ownership complexity impacts their personal financial plan. Topics that we cover, outside of this, 401k plans or what retirement plan makes most sense for you as a business owner. Tax code changes. We'll be doing some stuff because there's a new tax code in place this year. In the past, when during COVID, we had PPP loans and the earned retention credit, we just became experts on that. So that is our focus. Again, personal financial planning, wealth advisory for business owners and their families. And let's see, what type of law does Tina do at Husch Blackwell? I know Husch Blackwell, they do a lot of things. So maybe, Tina, if you don't mind, talk a little bit about kind of Husch Blackwell, then also talk through kind of where you specialize.
Sure. Thanks, Brian. So Husch Blackwell is a national law firm. We're a Midwest national law firm. We're not one of the East Coast, West Coast headquartered national law firms. We're actually headquartered in, there's always a debate, either Kansas City or St. Louis. The two cities always fight over that. But Husch Blackwell expanded to Minneapolis in 2023, and it expanded with a group of attorneys like myself who have been practicing in the state of Minnesota for over 20 plus years. And so it's not a East Coast, West Coast firm coming into town, but all a group of attorneys who have Minnesota roots and connections. We're a full service law firm. I focus on and specialize in employment litigation and advising and counseling with employers. Our clients range from sizes of one employee to 5,000 employees. So we have a whole host of things. But our view of it is we have a different approach on things. We organize in terms of business units, and we focus on understanding the industries that you're in. And we try to come up with business solutions. So it's really, we're trying to avoid the litigation for you all and come up with business solutions. So even though I do employment defense work, my passion is really doing employment advising and counseling and doing investigation work where we're trying to avoid the issue before you actually get a lawsuit from one of your former employees. So look forward to working with you all.
Yeah, that will we'll kind of go in the Q&A. I have some questions just around that of like, I don't know, more of the scenarios of what you've seen in the past, and then what you would anticipate seeing related to paid leave.
Yeah.
What, what do you predict the future to look like kind of around paid leave? So, all right, let's go back to some of the details of Minnesota paid leave. There's a lot of compliance around this. You don't want to get it wrong. As we said earlier, it impacts every business owner that has an employee. What you should be already doing is reporting wages and through the portal, and then just determining what employees may be eligible come January 1st. And then you have to figure out, do you roll with the state plan or a private insurance plan? I'll touch on that in a little bit. And then there's informing your workforce and then paying the premiums, and we'll talk through that in a bit here as well. On the employee eligibility, um, as you can see, who's covered is there's a lot of people. There's more employees that are covered than not covered. The carve outs are really only just the federal government employees, railroad employees, the exempt seasonal employees. I might ask you, Tina, some more information on that piece. But when I was doing a lot of research, just trying to better understand this, months ago, someone framed it as even your part-time employees are covered by this. Okay. The other thing is that from the business owner's perspective, if you are a business owner and you are drawing a salary, this is a benefit that you are entitled to. And so unlike a lot of us that, will probably opt out of the unemployment insurance, you can't even opt out. I guess that's the first thing, but also know if you have one of those qualifying events and you're the owner, this is something that you can benefit from. Those that aren't covered but can opt in are the independent contractors, self-employed individuals, tribal nations. And so for some of our business owners, a lot of them are working, they have employees, but if you're working with contractors, self-employed individuals, and they're not aware of this, I would just kind of inform them that they should be checking into this, especially if they are anticipating a qualifying event, having a baby, maybe caring for a loved one. It would make a ton of sense for them to opt in that case. But Tina, can the whole exempt seasonal employee, it's always confusing to me. Do you have a better grasp of like what that means?
Yeah, it's truly seasonal, and there's three factors that you have to be. One, you have to be in the hospitality designated industry. So when you think about that, think about like pop-up shops or the state fair. And it truly has to be qualified as seasonal, which is determined by the by deed. And then three, you can't have more than 150 days of seasonal holiday season. So it's three factors, and you have to meet all three to be a seasonal employer with seasonal employees. Otherwise, you have to be in this program.
Okay. I just had a thought, like, would that make sense for those that would want to opt into that program for those seasonal type of businesses? I don't know. Have
They
you got
they could opt in. They could choose to opt in if they wanted to. But I mean, I'm thinking like think about it as like the food stands at the state fair, where it's
sure,
truly a seasonal and they may be organized under a different entity than maybe they're
sure.
standing alone restaurants. So because you may have only a 2 week period of having those employees on the books, they may not actually qualify those employees because their wages may not be hitting the threshold amount.
Got it.
So it's just something to be aware of because people think it's a broad definition and it's a really, really narrow definition on that.
Okay, that makes sense. And that kind of alludes to the second point here of the employee earnings. So for that employee to be eligible, they have to earn more than 5.3% of the state annual average wage. The average annual wage in 2024 was 71,000. So approximately the employee has to make more than 3,800 for the year. And so that's again going back to the comment of even think about even your part-time employees are covered by this. Let's back up and just look at that first point. Um, think of it's even if you are a company based in Wisconsin or the Dakotas, but you have an employee that works here in Minnesota, they're covered. Okay. So employees are covered if they worked at least half of the prior year in Minnesota or if they live in Minnesota but didn't work more than 50% of their time in another state, they also qualify. So we can go through scenarios of like splitting time, but just think of it as if you're a Minnesota or a non-Minnesota company, but you have an employee that is basically doing the work from Minnesota, well, they have to be enrolled in the program. So just understand that. The new workers piece, even if they meet the earnings requirement, they are eligible, even if they just started with a new employer. Tina, you want to touch on that piece of it and like how is that even the case? So they just started, they're eligible, and then maybe kind of allude like how the whole job protection. Speak to that a bit.
Yeah, so two things. One, to go back to the prior point of the 50% or more,
Yep.
we have, you should be monitoring that from your perspective if they're more than, so it's on you as the employer to make
I
sure
suppose.
that they're less than 50% for eligibility. So it's on you to monitor that. In terms of the wages, if they have earned, it doesn't matter who the employer is. If they've earned at least this threshold dollar amount in the state of Minnesota for 2024 or 2025, it doesn't matter that if they're your employee. It's just that they have to have earned that much, and then they're eligible with you as a company. So a lot of times being asked the question of, well, what about the brand new 16-year-old kid that we hired for the job that's, hasn't earned a dime before that? They won't be eligible until they hit that dollar amount for
Okay.
this. So it's once they've hit that dollar amount, then they get enrolled. So that's another thing where as you're doing an intake, you should be asking that question where you're not having them disclose wages. You would just simply have them check off and say, yes, I've earned at least that amount to as a kind of your payroll paperwork.
Okay. So I just had a thought here. We'll talk about this a little bit on some other slides, but what we haven't told the audience yet is that if you have an employee that has had a child here in 2025, right, they are eligible and to go on paid leave as early as January 1st. And so the qualifier is they have to use up those 12 weeks before that 1 year anniversary of the child being born or adopted or placed into foster care. And so you could have someone that you just hire, right? And you may not know that they had a child in 2025, and they could roll, say you hire them hypothetically December 1st, they could then say, okay, I guess they got to give you what, a 30-day notice, right? And they say, you know what? Now I'm just hired, but I was working in previous jobs, so I qualify here. And come January 1st, I'm going to start taking paid leave. And I guess where it's not like there's, I guess we'll talk a lot about job protection here because that job protection kicks in 90 days, but you have some other slides that like there's other job protections kind of related to the whatever Minnesota parental leave one. But so I guess my point being is just like, even if they're not, well, just be prepared that you're going to probably have some employees that are looking to take leave as early as January 1st if they had a child in 2025. And understand that even though that they may not have been working for you for 90 days, if they had previous employment, they could qualify right away.
Yeah, it's a good point, and that goes for male or female employees.
Yep.
And just so you know, obviously to avoid any litigation, do not ask anybody the question whether or not you've had a child in the last year.
Yeah.
So I just am giving that advice to you all.
Yep.
But yeah, male or female employee can start January 1 and they can say, well, oh, by the way, I wanted to let you know, or December 1. And then starting January 1, they can say, I'd like to take the leave. My child was born in September. And so I'd like to be taking this family bonding time, which they're eligible for under the statute. So just be careful of that and be mindful of it. I'm jumping ahead, but I could see this being an area of potential litigation for employers not hiring a female or kind of retaliating against a man for taking that his right to have that leave. So
That,
just
that is a question I had kind of queued up my own question. is what it would, and that's just be prepared for that, I guess.
Yeah, it's going to be a swimming pool for plaintiffs' lawyers.
Okay. Oh, do you do that type of work? It'd be a busy, no.
Yeah.
No. All right, so let's move on here. This is now the benefit the employee will can receive. The calculation is kind of complicated, as you can see there. Just know that the max weekly pay is $1,423, and I'll show you in another slide that makes a lot more sense of it. Also note that you as the employer, you can top off the benefit um, to make them whole. So if they are going to receive, 70% through paid leave, you could top them off at 100% if you so choose. Or we'll see in other slides, the employee can also use paid time off, vacation time for that too. But let's just kind of go and make some sense of it here. I like this chart. If we look on the far left, that is annualized wage. So think of your employees, right? And let's just focus on the $50,000 employee annually. So before paid leave, their weekly pay at 50,000 is $962. If they would have a qualifying event and go on paid leave, they would receive $805.37, which represents about 90, or is that 84% of their gross benefit. And so you can see as that gets higher, kind of that break even point is at 103,600, right? Then it's maxed out at that 1423. So someone making 150,000 through paid leave, they're going to replace about 49% of their gross benefit. Someone at 200,000 at 37%. So a couple things to consider, I would say as a business owner is if just at that replacement of income, it's probably a fair expectation that you're going to see we'll say the lower income in this case. If they do qualify, probably more likely that they'll look to extend all the way up to the 412 weeks. Someone more higher income, it might be harder to take that much leave without any type of supplemental benefit. And then again, just for the business owners, you can have a policy to supplement pay, including yourself, to make you whole on that. And we've been asking the state if like draws or distributions as a business owners impact the benefit, and they've come back and said no, that doesn't impact the paid leave benefit. Okay, so we already touched on this, so this kind of move quickly. As I said before, it's funded through a payroll tax, a premium rate, effective January 1st. So make sure your payroll is set up January 1st to start pulling this and withholding this, right? For a standard employer, so 31 employees or more, as I mentioned before, the premium is 0.88, half of that paid by the employer, half of that paid by the employee. And again, if you're a small employer, 30 employees or less, the employer gets a discount at 0.22. The employee pays the rest at 0.44. You pay this premium up to the Social Security wage base, which in 2025 is 176,100. So if you have someone making more than that, then it's capped that premium tax for Minnesota paid leave. You as the employer, you could choose to pay for all of it or more than just that minimum amount. I just don't know, in my opinion, why that makes a ton of sense. I don't think you're going to recruit any, talent based off of that compared to the other employer. So, I don't know if that is worth considering. And it actually we could probably have a whole nother presentation of how it impacts, which you would go on to benefit the taxation of that, because that's a whole can of worms too. So, long story short, probably just paying the minimum amount as an employer makes a ton of sense. And just on that small employer, 30 or fewer employees in the average wage of all employees is 150% or less of the statewide average. So that's 107,000. So the average wage has to be below 107,000 with 30 or fewer employees to qualify for that. So think CPA firms, law firms, architects, kind of like those high, service firms, computer programming, they may not be able to qualify because both of these have to be true. All right, so let's just look at a quick example. The top one is the standard, or I'll say the large employer. If we look at 2 million in payroll, the annual premium is that for the employer is 0.44, so 8,800. If we go for a small employer, that same 2 million in payroll is now 4,400, which represents that 0.22. Okay, so just kind of showing the discount that small employers receive. You do, as an employer, have an option to either go get auto enrolled into the state plan or move to a private insurance plan. If you move to a private insurance plan, it has to meet or exceed the state benefit. And, what I'm guessing is the private insurance plans, as far as the benefits, are going to basically, they're going to look the same to the Minnesota, at least what I've seen so far. Where you may want to consider a private plan is maybe just the service you might get and potentially a discount on the rate. Let's see if I don't have that slide. Um, if you are an employer and you have 24 employees or less, and you are 40% or more male, there's a decent chance that a private insurance plan could make sense. We can help get a quote. So just reach out to myself or anyone on my team at eWealth Partners. And if you get enrolled into the state plan, just know that you can make a change quarterly. Ideally, you probably would want to get this squared away ASAP, especially if you're going to move with a private insurance plan. You have to file this exemption with the state by November 10th. But we're hearing from all the insurance carriers that we're working with on this. They're pushing up out their own deadlines. So long story short, reach out to us if you want to get a quote because you got to get moving on that ASAP. All right, so we talked about reporting wages, which you're likely already doing. Just it's through the same system of where the unemployment wages are reported. Figure out if we want to select a private or a state plan, and then we kind of get into more of the compliance side of informing your workforce. The first insurance or the premium is due in arrears, so it's in effect January 1st. And so the first premium is either due to the state or the private insurance plan is by April 30th. Okay. I think I touched on that here. So October 31st, and we're even pushing that up because that's the feedback we're getting from the insurance carriers. If you are looking to get a private plan, get a quote ASAP, reach out to us or whoever you're working with on your benefits, because November 10th is the deadline to file that application for the private plan exemption with the state. And then Tina will touch on the December 1st notifying employees. We have a slide on that. And then January 1st, make sure your payroll is set up to start those deductions. And as I mentioned, April 30th is you have to make those first quarterly premium payments are due. Before we get into the notifications, Tina, you want to take this on just the whole intermittent leave of what you're seeing and expectations, how it works, policy, company policy?
Yeah, so the answer is yes, they can take intermittent leave and there's guidance from Deed on this, but they can do that. And especially for smaller employers or employers where you might have, I think oftentimes of the manufacturing plants, those who are working on the line where you may have their specialized skill set and you may need them for working on the line because of their skills. And so they have the right to take it intermittent. You can't force them to do so, but you certainly could encourage it and have that dialogue. And so we're seeing a lot of employers putting together communication programs on this. It would be similar to if we were doing an accommodation for a disability, where you could talk through an intermittent leave. So this is a good example where for medical leave or for family leave, they could do that on an intermittent basis. So, Brian, looking at the slide of the person with that $200,000 wage threshold and what they're getting for the weekly benefit, it may make more sense for them to do intermittent PFML
Sure.
where they have that time off. And so we have the documentation in place. So we should be working with your employees on that, and you should have a written policy saying that we can work with you on this and that there is an intermittent leave option available. So you just want to make sure that you have a written policy on that. The the company has the right on intermittent leave to make the determination if it's going to interfere with our operations or unduly disrupt it. So it may be one where they want to, if an employee says, I want to do intermittent PFML every Mondays and Fridays, but every Mondays and Fridays might be critical days for you and your operations. You can say, we can't do those days. We can do Tuesday, Thursdays, or something like that, but you work with them. But if it's something where it would unduly disrupt the operations, maybe it's the payroll person who needs to be in the office on Fridays to process payroll. And we always know that you have to say that we need to have that individual present. So it's more about what we would call it an interactive discussion. And then make sure you're documenting that interactive discussion. So you don't have an employee later say, I was denied this. And we can say, well, we documented this and we've sent you a follow-up email, and documentation can be through an email follow-up on these things.
Okay. In the event though that if the employer doesn't really have a choice if they have the qualifying event and they want to take it all consecutive, right? It's just
They have the
so
right to do that.
okay.
Yeah.
It's if it is intermittent, they have to work with the employer, and that's where like kind of it can be a good thing for the employer and the employee. Like, hey, let's work together on this. And then it's also just again to note as a business owner, if you have a qualifying event, um, we all know that it's hard to just put pause on the business, that you could have within your own policy that you're going to work whatever 2 days a week, 1 day a week, and then the other days essentially be eligible for the paid leave. So it could work well for those business owners that have their own qualifying events. All right, let's go into job protection and anti-retaliation. So I know this is a big thing. And how do business owners and HR departments, how do they protect themselves too?
Right. So I think a couple of things is that the statute says you have to be the employee who takes PFML has to be restored to the same or equivalent position. So in other words, if that individual was in, let's go with sales, and they were in sales and their region was the Midwest, and obviously let's say that they took the full PFML of 20 weeks. Well, you obviously are going to have to backfill for that position in that region for sales. So you would just have to restore them either to the same region or just restore them to the sales position with no loss of seniority or wages. You also have to allow them to retain their benefits and insurance while they're on PFML, but you can still require them to make premium payments. And so we've been putting together policy language where if they don't make their contribution payments though, and we within 30 days, and we give them 15 days notice, and they still haven't made it, they could lose their benefits coverage on that, just for the insurance benefits coverage. And then they could be restored after they fill it back in. I view it as a lot like for the employers who have 50 or more employees, FMLA is very much that way, where we have that right and protection for the company to get the money so that you can try to be able to recoup those things. But a lot of times we're seeing that the employers are starting to put into programs that you have to issue the payment or authorize a wage deduction, or some type of payment has to be remitted to the company so that they retain those insurance benefits. And finally, you can't retaliate against somebody who takes it or requests PFML. So think about that employee who started December 1, discloses on January 1 that they want to take PFML. Now they don't get the job protection that day on January 1 because it hasn't been 90 days because they're your new employee. But if they say we want 12 weeks of PFML, they'll be hitting right at the 90-day marker. So you can't fire them while they're taking the PFML or making the request for it. So it's one where just be careful that you are restoring them to the same or equivalent position. That's where that interactive dialogue might be a place where you might be a small business owner and you do have people that are covering sales in certain territories. And then you have this disruption of somebody being out for 20 weeks and somebody else had to go in there and fill that position, is saying to them, we're keeping you in sales, but just not in the same territory. But we want you to do X, Y, and Z until we rebuild it back up. It's a really careful dialogue. Just think through your dialogue before you meet with the employee is what I would say. It's a really good practice is having a prep session before you have the meeting with the employee who's returning back.
Okay, that's interesting. So talk me through that employee that went on leave. You were potentially even going to terminate them before they went on leave, but you didn't know that they, had this qualifying event. How is the employer and the say the HR department, how do they protect themselves? What should they have done? What should they have documented? So we don't have this fear that the employee is going to come back to them with
So great question, Brian, and I will tell you that don't kid yourself. Every employee knows their rights of protection, and they
Sure.
also somehow know that they're about ready to be in trouble or be fired. And so they're making these types of requests. So I think again, get your documentation in place, make sure that you are having what I would call confidential, at least email communication somewhere where, as I'm a defense attorney, I'll ask that question. Were you guys having pre PFMLA request discussions about performance issues and possible termination? I have just dealt with this in another case. It wasn't a PFMLA case, obviously, but it was an accommodation request and a leave of absence request that would have been considered a protected leave. And we had great documentation showing that there were ongoing performance issues and documented performance discussions, and that we were in the process of getting ready to fire the individual. So the request wasn't in retaliation of that
Sure.
request. It was because we were ready to fire the individual, and it just happened to be a simultaneous situation. You may want to pull back on the termination. You may want to say, all right, we are going to put you on a performance improvement plan. And then when you come back, you still will be having to abide by that performance improvement plan. So you may want to take a more conservative approach and pull back on the actual termination and proceed with that way. So just be ready to be prepared. Your employees, your underperforming employees, you might want to evaluate them now before this goes into effect January 1. And if you've got an underperforming employee now, I would address those performance issues now and get those going.
Got it. Yeah, and it's also, a good time to start thinking through if you haven't already of like just your whatever your org chart and who are the backups and all of those policies and procedures in place.
Yeah.
Because I think it's fair to say that it's probably more likely that you're going to see, especially for the smaller employers, more of your employees go on leave than you ever have before. And it might come, as a surprise of when they might have that qualifying event. And so just be prepared for that. All right, so let's go to the notification or basically what needs to happen December 1st. Talk us through that.
Sure. So you'll want to make sure you have workplace posters up. Especially, so I've been asked this question, what if we only have one employee in the state of Minnesota and they're a remote worker? Do I need to give them this workplace poster? The answer is technically yes. But here's what I would, and what we're advising is send the workplace poster to them via email. So we're
Sure.
saying, here's your workplace poster, and they have it. And you have to, if you have more than one employee and you have 5 employees, and let's say that 5 or more employees or independent contractors, that's the key. Independent contractors too are accounted for these workplace posters, even though they're not part of your opt-in and we're not responsible, you have to count them. So if 5 or more employees or independent contractors speak a different language other than English as their primary language, you have to have workplace posters for that English and that other language. And Brian's making a face. Yes,
Yeah, like that's kind of wild that we have to be responsible as we as business owners have to be responsible for the independent contractors.
on the notice. Yeah.
Okay. So I
And
guess,
then, yeah,
yeah. All right. Good. Okay. Carry on. Okay. So then
and
there's that, and then there's
then,
probably this piece, right?
yeah, that's also, then you have to do an individual notice. And the individual notice, I was just asked this question this morning, can I just send them our handbook policy or the workplace poster? And I'm like, no, you actually have to send a letter to them or a memo as an individual notice in their primary language. And then the employee has to acknowledge receiving it. So there should be a lot of rollout meetings. I view it as a lot of health insurance benefit rollout periods. So you should be thinking of it that way. And you can have them just e-sign. So an e-signature, you don't need a wet signature on this. Or some of our clients, they do it through a tracking system. So it just shows that they got it and that they've acknowledged it through like even initialing it. The individual notice, maybe Brian, the next screen, which is where we laugh a lot. This is what the state of Minnesota says. This is what it should look like. And this is a template that the state has. I would recommend you having a far more simple notice for you as a company. And you kind of hit like you have the right to take this policy or this leave. And the big thing is letting them know like what is for. And you kind of hit kind of the highlights of it. It's for medical leave or family leave. And I would put in language that they are considered eligible because they live in the state of Minnesota. If more than at least 50 or work in the state of Minnesota at least 50% of the time. And if it's a new employee, you might put it in their new hire orientation packet if you knew that their wages, or you could say it's something like once you've hit the qualifying threshold, you'll be
Sure.
eligible for this. The main reason why that I think the state wants this written notice is that it is a payroll deduction to the employee.
Okay.
And I will tell you, employees do not understand that they are having this deduction. They think this is free money coming to them. And they don't realize that this is something coming out of their wages. So just this is a sample notice. We're working off of kind of what they would require, and we're putting together a template for employers. And so I would just say you don't need to give the phone numbers to deed and emails to deed. I would not, that's not required under the statute. So you do not need to say like learn more, other ways to reach us. That's not required for you as an employer. And I don't encourage our employees to have phone numbers to the state of Minnesota to make complaints about us.
Yeah. That makes that makes sense. That makes sense. Um, oh, I had something. It'll come back to me here. Well, I'm waiting on that thought. Talk through this whole paid off and what are the rules behind that?
So if you as an employer have PTO or vacation, or a lot of companies, smaller businesses, I see unlimited PTO or unlimited vacation. I want you to think about that because you can't force them to exhaust that PTO or vacation before they use the PFML. You can say that it can at their election run concurrently with the PFML, but it's at the employee's election. You can't force them to use it though before taking it.
Okay. So if your company doesn't have the employer providing supplemental pay, the employee can use their PTO to make them whole. And that just kind of sounds like a nightmare on the payroll side of it to figure out that whole piece of it.
It actually isn't, because think about it, you're only paying it's so view it as an unpaid leave of absence or a leave of absence and they're using their PTO, because you're not in charge of the payments that are being issued by either the private insurance or the state. The state's handling all of that. So that's not your issue. And it might be actually easier because then you can take that deduction for the benefits, the insurance benefits for that. So you can take that insurance premium payments that they're owed.
Yeah, okay. So for if either way, if the employer chooses to do something supplemental, it's some part of me says like it might even just for the headache, to do some supplemental just to cover the
Yeah.
benefits piece. Otherwise, that would be one way for, you said part of the policy, that if the employee that they still have to pay their fair share, of the premiums due for their health insurance and dental insurance. If they're using their PTO, then they can just kind of essentially pull it from that whole piece of it. The other interesting on that piece is that if there is any type of, topping off through PTO or through the employer supplementing it, now that's a W-2 wage, and that wage is now subject to the same payroll tax, from Minnesota paid leave and then also Social Security and Medicare. So just kind of keep that in mind. Explain a little bit more on the whole why why unlimited PTO could get you in trouble as an employer.
So the statute is really clear. They're just saying you can't require them to exhaust it before using it. So if they have unlimited
Sure.
PTO, so to speak, then they could just say that I'm taking a
Sure.
leave for medical reasons, but I'm not taking it as PFML leave. So they could, if you have a policy where you say, oh, we also have a policy allowing you to take a leave of absence for medical reasons. It's one of those things where I don't like, well, the unlimited PTO for smaller businesses and for people probably like you and I, we have unlimited PTO, but we don't use unlimited PTO because we have our obligations and responsibilities to our clients and to our customers.
Yep.
But for maybe those who are in lawyer and lower ranking positions and maybe less
Yep.
earning wages, they're kind of like, and maybe a different mindset. They may be like, I'm just going to take unlimited PTO. You can't force me to do PFML for having the birth of my child or for going to medical appointments.
Yeah. Okay. All right. That's helpful. All right. Let's move on here. Talk through paid family medical leave and earn sick and save time. Because that was that in place? Was it 2025 or 2024?
2024 it went
Yeah.
into place. Yeah. So it does not replace ESST leave. So you still have to do an accrual of 1 hour for every 30 hours worked with a minimum accrual of 48 hours with the carryover 80 hours. It still has the same job protections and anti-retaliation protections. And you can't require them to exhaust this before taking PFML. Now, again, this isn't a good example where you could, at their election, allow the employee can allow have it run concurrently with PFML. And that's really, again, Brian, with those higher wage earners where you're showing that there's that big gap of what they're going to get for PFMLA benefits versus what they would be getting if they were working full time. So, but it's the employee's election to have it run concurrently. And they could just say, I want to go take the PFML. Now I want everybody to think about this. So let's say the employee says, they had the birth of a child and then they had the bonding time. So 20 weeks, right? Maximum. Or there was a medical issue that they had separately and a birth of a child. So there was bonding time and maybe also their own personal medical. And then they say, well, I don't want to take my ESST. And if they've got 80 hours of accrued ESST for your year, that could put it to 22 hours
Yeah.
of a leave of absence. 22 weeks, excuse me, 22 weeks of a leave of absence. So I want you to think about that.
Yeah. I
So
haven't thought about that. That's actually interesting. That makes
it's
sense.
so you might want to just encourage them that they can take it concurrently so it's a wage supplement for them. But like you
Okay.
said, then it's a payroll tax too.
Okay. All right. All right. Let's move on to the next one. Parental leave. Minnesota
Does
parental leave.
not replace the Minnesota parental leave, which is 12 months. Or they can take 12 weeks of unpaid parental leave following during the pregnancy or following the birth or adoption of a child. It has to be within 12 months. And so think about this as terms of that could add on to the 20 weeks plus the 2 weeks of ESST plus 12 weeks of pregnancy leave or parental leave. So you could be looking at 36 weeks of somebody being out in one calendar year. So you just need to, you can require it to run concurrently. That's the good news. But
Okay.
you'll want to have a policy in place saying this runs concurrently. This is one where you can require it to run concurrently. So you're
Okay.
not getting that 36-week stack.
Okay. So
Written
uh,
policy.
do that. Do that. Okay, that makes sense. All right, now FMLA, Family Medical Leave Act.
So this is only for employers with 50 or more employees. You still have to provide all the FMLA paperwork, and it still has all the same job protections and anti-retaliation protections. Again, this is one where they get up to 12 weeks of FMLA if it's a qualifying leave. And so, but again, this is like the parental leave. You'll want a written policy saying it's running concurrently with the FMLA. Otherwise, you're going to have another stack of, you could have 48 weeks potentially.
Yeah, and
So,
that's a good example um for this year. You might have an employee that had, a child and then went on leave through FMLA and used what, all 12 weeks. And then come January 1st, it's, a new program and they could go on Minnesota paid leave come January 1st or any time before that 1 year mark of the adoption or birth of the child.
and I'm dealing with that. I'm fielding a lot of those questions right now.
Okay. I can understand why. Um, all right. What are just some best practices that you recommend here?
So I think, like you had noted, the key deadlines, you've got to pay attention to the upcoming deadlines. And December 1 is the critical deadline in terms of the communications that need to be had with the employees. Update your handbooks. I was telling Brian before we started this, I've had a lot of phone calls with a lot of employee handbook updates, including one that's 20 years old. So look at your handbooks and make sure that you have language in those handbooks in terms of running things concurrently, or at their election, they can have it run concurrently with that leave. And then doing a lot of education with your employees. And that can be done, through webinars like this or through in-person meetings. But again, a lot of employees, they don't understand, one, that they're contributing, and two, they don't understand that the company's not making the determinations. It's either
Mhm.
the state or the private insurance is making the eligibility determinations. We're not involved in that at all.
Which I could see being like a good thing. Like we don't want to get our hands dirty with it, but then also the employee's likely going to come back to you as the employer or the HR department to say, hey, where's the money if things are, backlog type of thing. Talk me through a little bit more just when they reach out to you and you're helping them like update the handbooks. So maybe just even audience members here, like how would they do that? Is it like do you provide like a consultation or just things to consider and what does that look like? And then how do you work with them on that piece of it? And then maybe going into next year just explain to me like what are other scenarios that an employer might reach out where you can help them out.
Sure. So the handbook is one where we do a lot of preliminary reviews of the handbook, and we'll just say, look, it's a flat fee we do.
Yeah.
And we look through the handbooks and we'll say these are the things we would recommend to get current with Minnesota law, including things where I'm seeing handbooks that do not have the ESST mandatory policy in there, or the
Hmm.
PFML policy, or maybe there's like no parental leave policy or school activities policy or things like that that would be required under Minnesota that we would want to make sure we have in place. So it's one where we look at the size of the employer and then we work with them in terms of what that would be, because sometimes we're also dealing with multi-state employers. So we're putting together some state-specific addendas, but we're just
Sure.
making sure it's all in compliance with the applicable law. And then we work through like how do you roll it out and communicate with the employees. In terms of what I anticipate, I had a mediation a few weeks ago with a fairly well-known employment plaintiffs law firm. And the mediator actually was a plaintiff's employment attorney. And I said, I feel like PFML is going to be your next little hotbed of trying to get
Yeah.
you. And he started laughing, and he didn't confirm or deny, but just he gave a very friendly smirk. I think it's going to be one really more, it's going to be centering on the retaliation and the job protections. I don't think it's going to be
Okay.
about allowing them to take the leave. It's going to be about any type of retaliation, including snide comments to, in particular, and I hate to say it this way, in particular to men taking family bonding time.
Sure.
And it's just, it's a reality in my industry. I work with employers all over the country in different sizes. And so there are sometimes that issue. And then there also could be some anti or some retaliation issues for failure to hire a woman who you see coming in for an interview as 7 months pregnant, which I did for one of my law firms. And you as a smaller employer or a large employer are thinking, okay, but if I hire her, she's having a baby in 2 months and she's going to be eligible for PFML. And so I'm not going to hire that pregnant woman. Or somebody discloses
Mhm.
in an interview, which happens also, where they sometimes candidates they overshare about medical situations or about family issues. And so you might not hire them. And so we might have a failure to hire in retaliation for these things. So it's one where good documentation is critical for, it's the thing I say all the time. And one of the things, there was a study done in about a decade ago is about juries. Juries believe employers have the right to make employment decisions. Juries believe employers have the right to make decisions about hiring and firing, but juries want documentation. And in
Sure.
particular, when you're getting ready to fire that employee, it's not because of them taking any type of leave under the PFML or whatever protected leave. We're firing them, as you mentioned, like, what about this bad performing employee? Well, we've got good documentation to demonstrate all of these things. And
Sure.
so juries want to see that there's good documentation and that they believe paper over people. And that's just the reality of the study. So document, document, document.
And does that help something that you kind of help coach up the employer, the HR department of, in an interview process to the performance reviews of,
From
that
hire
side
to
of,
fire, we have a whole coaching process of from hire to fire. And that's
oh,
the life of an employer. Unfortunately, we're not hiring people to fire them, but there comes a time where you do have to fire them.
yeah,
How do you get to that point? And the big thing is also, as you're thinking about this as a business owner, is what do your performance reviews look like? Because are you doing performance reviews and what do they look like? If you're giving them the Minnesota nice feedback, which I jokingly say I'm not from Minnesota. I didn't grow up in Minnesota. I've lived here more of my life in Minnesota, but
yeah,
I wouldn't say I'm Minnesota nice. So I still have this direct communication. And you need to have direct communication if there's deficiencies in the performance, either at the performance review or even in email documentation saying, these are the issues we're seeing. Now be nice, don't be
yeah,
mean,
yep,
but
yep.
giving the real-time feedback is so critical for employers to be able to get to the fire. If you get to the fire, it's remarkable how quickly plaintiffs' lawyers will have calls with me about how do we get this resolved without litigation.
Oh, okay.
So,
That makes sense. Address it, right?
yeah,
Make sure you're addressing it the right way. All
yeah.
right, let's open it up to any questions. I'll check the chat box here. We're coming up to the hour here, but so if any of you have any questions, um, what I was thinking through, and you addressed it, is when they have the qualifying event, then they have to basically put the claim either to the state's portal or the private insurance piece. At that point, the employer is not involved. Is there any, like, I don't know, legal action or anything like that they have to do on their side that we have to be concerned with, or
They should be having, in terms of the state or the private insurance, they should be having communications with them. And it's similar to an unemployment insurance where they update it, and there should be. Now, I was laughing because I think KSTP had a clip on the news last week about how there's challenges with the rollout of this new program. The state has hired 200 employees to man this up, but there should be a kickback to the employee saying, hey, we've acknowledged receipt of this and we'll be in touch with you.
Oh,
So
okay.
that's how it should be. They
Okay.
should be getting that. But again, I think it's one where training your HR or payroll or whoever is getting fielding questions from the employees of, here's what you need to do, and you need to get to the link to the state and upload that information. We're not involved in this. So that's that communication piece.
All right, I'm gonna pull up a slide with contact information. Is it fair to say if they have questions, your email is on the screen there,
Yep.
phone number, or otherwise you can reach out to me, put you in touch. Any final closing remarks from your side around this?
I would say really in the next month, make sure you've got the written communication ready to go. We're also doing a lot of PFML policies. So we've got a template. I'm willing to share it. We've done it through the state program as a large employer, but we have a template that you can work off of and tweak it for your own company's business. But we're happy to share it with everybody.
Okay, cool. All right, yeah, I'd like to see
I'll
that.
get that to you, Brian.
Cool. All right. For those, just know that we're gonna have future events on this. I'm sure, Tina, maybe we could even do this into the new year when we have when the it's in place and what are we experiencing. I'm sure there's gonna be some creative ways of how employees are utilizing this that we might want to talk through and how to protect us as employers. But thanks for everyone for your time today. Tina, thank you for being an expert on this. And enjoy the rest of your day.
Thank you.